Alright, the alleged suicide of Puran Kumar, a senior Haryana Indian Police Service officer who shot himself at his Chandigarh residence, has surfaced and raised many questions. Hello and welcome to NewsX Deep Dive, where we delve into details of the biggest stories of the day. Born on May 19, 1973 in Andhra Pradesh, Kumar hailed from a modest family that emphasized the values of education and resilience. He pursued his higher education in engineering, earning a Bachelor of Engineering in Computer Sciences, a field that was emerging in India during the 1990s. This technical foundation likely influenced his analytical approach to public service. Additionally, he held a postgraduate diploma in management communications from the prestigious Indian Institute of Management, Ahmedabad. Kumar joined the Indian Police Service in the 2001 batch allocated to the Haryana cadre. Over his 24-year tenure, he rose steadily through the ranks, taking on challenging assignments and advocating for transparency. This background begs the question, what led him to suddenly take his own life? Kumar left behind a 9-page suicide note recovered from his pocket in which he accused 12 police officers of mental harassment. The note specifically alleged harassment, discrimination and administrative bias. It accused Director General of Police rank officers of repeatedly harassing him by issuing unnecessary notices. Kumar also named 7 to 8 IPS and 2 IAS officers allegedly administrative interference, discrimination in postings and bias in official reviews. 2 days after the incident and nearly 24 hours after his wife, IAS officer Amneet P Kumar filed a formal complaint. The Chandigarh police registered an FIR and the FIR was filed at Sector 11 police station against all those named in the final note on charges of abetment to suicide and under sections of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. The complaint was based on the 8-page suicide note which named 8 senior IPS officers with specific references to Haryana DGP Shatrujit Singh Kapoor and Rohtak SP Narendra Bijarnia for allegedly harassing and maligning him. In a formal complaint, the victim's wife also pointed out that just before his death, a false FIR under Section 308 of the Bharatiya Nyaya Sanhita had been registered against her husband's staff members at police station Abran Estate, Rohtak, dated October 6, 2025. She alleged her husband was implicated in the case through fabricated evidence, which pushed him to his final anguish. Furthermore, he was reportedly subjected to caste-based slurs and excluded from places of worship on police premises. This brings up an important legal question regarding the terms involved. Abetment to suicide under Section 198 of the Bharatiya Nyaya Sanhita involves encouraging, inciting or assisting someone in committing suicide. The punishment for this can extend up to 10 years of imprisonment in addition to a fine. Meanwhile, dying declaration as per the Bharatiya Sakshya Adhiniyam refers to a statement made by a person who has died explaining the circumstances of their death. Such a statement can be proved when it relates to the cause of death or any of the transaction circumstances that resulted in their death. A very prominent example that comes to mind is the case of actor Sushant Singh Rajput. In Rajput's case, the charge of abetment to suicide emerged prominently after his father, KK Singh, filed an FIR in July 2020. The complaint accused Rajput's live-in partner, actress Riya Chakrabarti, her family and others of mental harassment, wrongful confinement, financial embezzlement and administering psychotropic drugs. Riya Chakrabarti and her brother were eventually exonerated in the case after spending 27 days in jail. Now that a 6-member special investigation team has been formed to probe this case, what can be expected is the big question here. Mr. Ashwini Dubey, advocate on record, Supreme Court, joins us on the program to talk more about this. Ashwini, first up, abetment to suicide in itself is a very grave, a very serious crime. And secondly, this officer was decorated, he was educated. If he was being denied opportunities, if he was being discriminated against, and that led him to take this final and deadly step, it's abhorrible, and at the same time, it's not permitted under the rule of law. If he's being pulled up or discriminated against despite his position because of his caste, what can the law do here?
If the allegations are true and he has been denied just on the basis of the caste, the real benefits, the service benefits which were to be given, then of course it's a case of serious concern. Because then it would result, it would not be treated as an ordinary suicide, but a direct result of the systematic persecution, and that too by the senior officials of an officer who is from the SC community, and that too by the powerful and high ranking officers who have used their positions to mentally torture him, which led to death. Now that would reveal, Vinit Bhai, as you rightly said, the SIT has been constituted, SIT would look into it. But the question here is, what led the senior IPS officer to commit suicide? That's really a problem of worry that is happening in the force. Abetment of suicide is no doubt if any person commits suicide, as you very candidly pointed out the provision of law, that whosoever abates the commission of such suicide shall be punished with imprisonment of a description which may extend to 10 years. And to understand the abatement, there is a need that instigation to commit an act. And if that instigation, Vinit Bhai, is by the senior officers or the people sitting in power, then of course it's the question which must be dealt as per the law. Engagement in conspiracy for its commission and the intention aiding by any act or illegal omission. And if three ingredients establishes the mens rea or guilty intent to provoke that act and that to which finally took his life, an active or direct act of instigation and a proximate and live link between the conduct of the accused and the act of suicide, then if it proves, then the senior officers who has been named in the FIR would of course would be subjected to the law of the land. Vinit Bhai. Over to you.
Right. Well, Ashwini, also explain to us what abetment to suicide and dying declaration actually means, when this is going to come up for questioning under the courts.
Vinit Bhai, dying declaration is defined in sections 26 subsection 1 of the Bharatiya Sakshya Adhiniyam, which was earlier the Indian Evidence Act, which says that the statements made by a person as to the cause of his death or the circumstances leading to it is relevant whether the person making a statement was expecting death or not. And if these statements are proved before killing himself, before committing suicide, if he has written those statements naming those officers, it would be treated as a dying declaration. That can be oral also. What are the principles? That can be oral, written, electronic, and must be voluntarily truthful and authenticated. If courts rely on it, only if found reliable and corroborated. And what prima facie we are information which is coming through the media, news articles, that those statements have been written by the officer who committed suicide. So now the court has to look into it, because one of the argument would be there that this is this abetment of reason for abetment of committing this suicide, or this is the dying declaration. That would be decided at a later stage. But prima facie, if we see the note itself is a dying declaration, let us see how the court take into it. But the reasons which have been mentioned in the declaration of the latest 9 pages letters, that itself shows that there was a reason for committing such an act, and which is the punishable offense under the law. Vinit Bhai.
And Ashwini, also talk about what action can be taken in such cases. What does the full force of the law entail when something like this happens?
Vinit Bhai, the investigation is fair, independent, time bound, and for officers of high rank who have been alleged as an accused in this person, if they are not making any attempt to derail the investigation, one, and two, if investigation is done in a transparent, fair and time-bound manner, and a state government or the judicial authorities or the retired judges of the High Court or Supreme Court supervise these investigations, then of course in a time-bound manner truth would reveal. And if that happens, that those named in the FIR and those named in the suicide note face the consequences under the provision of Bharatiya Nyaya Sanhita section 108, which was earlier 306 of Indian Penal Code, and that would be punishable for the offense, which may extend to 10 years and fine.
Ashwini, if a serving officer pleads guilty to a case like this, what will happen to him?
Vinit Bhai, immediate suspension, which is the rules under the Central Civil Services Classification, Control and Appeal Rules 1965. This is under Rule 10 says so. And the dismissal or removal from service following conviction of a criminal offense involving moral turpitude, that would happen when the court makes them guilty, court found them guilty. And then forfeiture of pension and retirement benefits under the Central Civil Services Pensions Rule 2021, and bar on future government employment under Article 311 subclause 2 of the Constitution. But that would happen only when the fair, impartial inquiry is constituted. Vinit bhai, I must add here, if this has happened, this the question must be looked into not by the state SIT, but by the former judge of the Supreme Court or High Court, who must look into it, because a decorated officer from a humble background has committed suicide, who was serving as an ADG. It was not a simple person has committed suicide. That's the question which must be dealt. And if, Vinit bhai, other provisions, if there was no SC/ST Act offences committed, and there, if it is found in the inquiry that the offences of SC/ST Act have been misused and abused, then of course the process should follow against that person also. That is why there is a need to have an impartial, balanced view even before invoking the draconian SC/ST Act. But here in this case, tomorrow would reveal whether he was discriminated on the basis of caste, that too, that when the evidence would come. Over to you, Vinit bhai.
Ashwini, if somebody who is not in sound mind writes a person's name in their suicide note, what happens then? You obviously will have to establish insanity.
Yes, Vinit bhai, the mental condition of the deceased is crucial in determining the evidentiary value of the suicide note. This is one. Two, under section 124 of Bharatiya Sakshya Adhiniyam, a person who is incapable of understanding the nature of their act cannot be considered competent to make a reliable statement. Third, if it is proved that the deceased was suffering from mental illness, depression or delusion, court treat the note with caution, but it should be looked into from medical history of the officer concerned who has committed suicide. Was there any previous instances? That these are the factors which court look into and consider while awarding punishment. Over to you, Vinit bhai.
All right, Ashwini, always a pleasure having you. Thank you so much.